All right, so we're recording now. So for any of your board members that couldn't make it today, we'll provide you with information after this of how you can share it with your other board members or managers that may not have been able to attend today. All right, so some of the responsibilities, the role of the board generally is, and I put generally in there on purpose, is to oversee maintenance, replacement, and repair of the common areas and facilities and the condominium common elements. So everybody's pretty much aware of that, right? It's the association's job to oversee the maintenance and replacement. We're not having owners go out there and repair and replace the common areas or the common elements. The board is generally responsible for overseeing that. But what's coming up is really, what is the board's role? What is the association's role to prevent the spread of an illness or disease? And I think this is one of the biggest questions that we've been receiving, and it's really a tough one to kind of walk the line for your association. So most of you on here are probably either board members or managers. You've been elected, you've been hired to help assist the association with overseeing the common areas and amenities. And you have a lot of members that are probably asking you questions or looking to you for guidance on this. And so the difficult thing is you want to obviously make sure your people are safe, but we don't want to express it in such a way that the association is guaranteeing or somehow saying that it's taken on a duty to provide for the health, safety, and welfare of its members in such a way that people may think, well, I'm using the common areas, or I'm touching this elevator button. I'm sure that the association has been wiping it off every minute or so. Not that's an absurd example, but you know that the association is somehow going around following people with Clorox wipes and somehow wiping everything down to try to prevent the spread of the disease. That's not the association's job. It's not the board's job to try to prevent the spread of the disease. You certainly have the obligation to provide for the maintenance, replacement, and repair of the common areas, but it doesn't extend so far, in our opinion, in the way that we've been advising our clients on this, to take those extra steps. So Jim, did you want to kind of touch on that a little bit?
Yeah, so walking that delicate line, you want to take practical steps to address the situation given the resources that you have, but you don't want to, create the idea in people and create the potential exposure to liability where someone could, if an unfortunate event were to happen in your community, where someone would allege that the reason that they, contracted the virus is because the association failed to satisfy a duty to render the premises safe and free from disease. So that kind of goes in line with when you're communicating to people. Try not to begin your letters or send communications which indicate or say that the association's committed or management is committed to the health and safety of the members. You don't want to use terminology like that. You can express sympathy without using language that might be argued by someone to have created a duty on your part to prevent disease transmission and so forth.
Yeah. So going into the common area and the common element operation, you have emergency statutory powers. I have the Condominium Act and the HOA Act up here. I know we have some of our board members in here that are in cooperatives. There is a provision under 719 as well. They all are almost identical when you look at these powers. I will say kind of to start, the second bullet point, which is it for property damage only? And it says that the association through the board has certain emergency powers to respond, or if there's damage to the common property, there's some language about that. And the Division of Condominiums, Timeshares, and Mobile Homes came out recently to say, we interpret the statute, or we are allowing it to apply to HOAs and condos and co-ops during this pandemic. They use the language, we are suspending that it can only be for property damage, which I think is an admission that the statute probably needs to be amended in a future date to cover something like this again. The statute was written in such a way to contemplate, if a hurricane or some type of a tornado maybe came through, or some type of a natural disaster event that required some type of quick response for, shorter notice for meetings, considering the property uninhabitable or units or property safe for occupancy. That was more from a damage event rather than is, I said this the other day, we'd rather people stay in their homes right now. You want to keep them in their homes or their units as much as possible, not that we're trying to keep them out of it. But I think that if we're talking about what do we do with the common areas and the facilities, what do we do with our amenities, that's been one of the biggest questions. The most frequent question that we've all received is, what do we do? Should we shut down our pool? Should we shut down our fitness center, our basketball court, our tennis courts, whatever amenities that you have? And if you make the decision to do so, I think that you're pretty well protected under the emergency powers, where it talks about deeming association property or areas unsafe or not suitable to be occupied. Again, that came more from the property damage side, but because they came out and interpreted it as applying, I think that's what you'd be looking at if you were basing and closing down your amenities. It's very difficult for us as attorneys to tell you what you should shut down versus what you should keep open. The best that we can do is provide you with advice as to, if you decide to keep it open, here's how we would do that if you're going to communicate to your residents, or if you're going to close it, here's how you would communicate it, and here's how we would defend that position. By and large, though, I found it more likely or especially easy to defend if you close down a fitness center, which is a smaller space that has equipment that people are necessarily using, screens, that would need to be wiped down, and it's just very difficult to use that in a safe manner with the recommendations right now, as opposed to on the other end, which would be maybe like an outdoor pool or an open air pool area or a tennis court or something like that. I had one community association where it was an owner that contacted us, and he's an attorney, and he said, I understand everything else, but why do you have to close down the tennis courts? Because you don't have more than a couple people playing at one time. By the nature of playing tennis, you're pretty far apart. And so why can't we keep that open? And I advised the board in that circumstance, if you want to keep that open and post something saying, hey, you use this at your own risk, we're not providing any additional cleaning, or we're not, preventing the spread of the disease, again, be safe and heed any recommendations, and you were to keep it open, I think that you'd be protected from liability, most likely there. Swimming pools may be a little bit difficult. Some communities have said that they've removed some of their patio or their pool furniture to make it less likely that people will pull the chairs together and congregate like that. At some point, you can only do so much, and people need to have common sense and understand what they should or shouldn't be doing with the recommendations that are in place. So I know in different municipalities, up here in Northeast Florida especially, I haven't seen anything specifically like we have in Miami-Dade, where they actually came out and said that the pools, spas, and hot tubs are closed for everything except for a single-family residence or a townhome where it's exclusively used basically by that townhome owner, which I think they must be thinking of like a hot tub, above the ground hot tub that you go into once you walk off on your patio or something like that. But aside from that, that would seem to apply for condominium and homeowners associations, even though they're private, as opposed to being some type of a public entity or that it's owned by the county or the city or something like that. So until we have that, I haven't seen a directive and anything. And Jim, if you want to mention anything on swimming pools specifically, there hasn't been anything saying you should close or these must be closed down from a statewide level.
Right, from a statewide standpoint, no. And the statewide order, which we saw yesterday, is of course strongly encouraging and mandating, in fact, that people stay inside except when performing certain activities, one of which is exercising. So the bottom line, to tie it into the emergency powers as well, whether you can exercise emergency powers right now is somewhat debatable, but we think we can find ways to support the action you need to take and give you guidance on how you can take those actions without necessarily having to rely on emergency powers. And in terms of keeping amenities open or closed, there is a degree of common sense associated with it. Obviously, the more confined your space is and the more kind of hands-on people need to get in that space, like fitness equipment and things like that, the more likely it is that the consideration to shut it down should be, really strongly considered. But with things like open air pools or perhaps a tennis court, conceivably those things can be used responsibly under our current circumstances and under the law that is, as we're sitting here now, applies. So there is a bit of a judgment call. And, we think that there's room for those to be, to be used. But we also think it's defensible if you decide to close them as well. So you have a degree of latitude, exercise reasonable judgment there.
There was a good question. I'm going to answer it right now. And we've had this question a couple times, which is, let me see. There was a question from Miguel, which is, when the board decides to close amenities for 90 days, can the homeowners ask for dues to be refunded for the loss of service? It's a good question. The answer is no. Members cannot ask for a refund of their dues. There's a lot more that go to your assessments than just providing for the operation and maintenance of the amenities. You have insurance premiums, you have management fees, you have legal fees, you have landscaping services. There are many things that go into your assessments, not just for making sure that the amenities are up and running. There is a case on point from the standpoint of, and I've given this example, where a court found that an owner who thought that the association was not properly maintaining the exterior of their condominium, which resulted in water intrusion coming into their unit. They tried to stop paying their dues in protest, basically, and the court said, no, you still have to pay your assessments, but you're able to file a counterclaim or a separate cause of action if you feel like you were damaged in such a way that you otherwise are entitled to monetary damages. So if owners try doing that, that doesn't stop your power and our collection authority. If we are handling that for you, that's not a valid excuse for not paying your assessment. So it's a good question. It's something that's come up. The other thing that I wanted to address quickly regarding this, and I think especially Duval County beaches have been closed for a little bit longer. I know St. Johns County, and I'm trying to think of in Flagler County if there's been an order on this or from closing the beaches. But basically, one thing, I know we have some on here, some of our clients that are oceanfront properties, and one question that has come up is, do we need to close our walkovers to the beaches or not? And then that's another difficult question because of the applicability of the order closing the beaches. It's our understanding, and assuming that it's valid, which we are taking it that it is valid on its face, that the counties can do that, even if there might be some rights of the public to go out there, depending on the ownership, to have the beaches closed. Now, if you choose not to, or if you forgot, or if you haven't closed off any walkways to the beach, I wouldn't worry about liability from the county, for example, saying, hey, we have a bunch of people that are coming out from this association and we can tell that they're using the beach and we're having a hard time, it's in violation of this order. That wouldn't necessarily provide any type of liability on behalf of the association if you were not actively preventing them from doing that. Jim, give your example that you've given before of whether or not we need to specifically make people aware of what these orders are and if we're required to actively prevent that, I guess.
Right, so you're having governmental entities imposing mandates on people, but that doesn't mean that the association needs to be another enforcement arm, right? The obligation to enforce law is law enforcement. And similarly, we don't necessarily have an obligation to post notices, for example, if the law says they can't use the beach for right now. Just like we don't have the obligation to post notices saying don't murder people in our community, right? Murdering is against the law, and presently going to the beach could be against the law, but we don't necessarily need to have an obligation to post notices of either thing, right?
Yeah. So from that standpoint, obviously communication is key with everybody, and providing information. I'll get to that in a little bit on communication with owners. But again, going to emergency powers for the common areas in the property, it's based on the advice of emergency management officials, and I believe that was amended to say public health officials. I've seen that come out in terms of the interpretation of the DBPR and the order that came out there. Or advice of professionals retained by the association. The board may determine any portion of the association property unavailable for entry or occupancy. That first bullet point is more what I think would apply to common areas. That's for entry or occupancy, whereas the second bullet point is more going to habitation for actually people living in their units or their properties, which I don't think would apply as much here. One question that's come up is, well, can we only allow owners to use the amenities if we're keeping them owner, but can we keep out guests and tenants? I think that's a difficult thing to enforce if you're going to have it open, and the statute doesn't say that you can differentiate between closing them down to everybody but the owners. It kind of says that it applies to everybody, and there isn't language in there that would give me comfort to tell you that you can differentiate and say we're only going to allow this to be open for our owners. So just be careful if you are contemplating that. Again, still staying with the restriction of the common area and amenity use, it's on a case-by-case basis. And again, you have a lot of factors to consider: the health and safety of the residents, potential liability of the association, and the right of owners and guests to use the amenities. So again, you're probably hearing from us. I know we would love to be able to provide you with some black and white answers here on you should keep this open, but you should close this. I don't have that. I think it depends on the nature of your community. I completely understand. Look, if those of you have known me, I've got 4 boys at home right now, and I think if I was in a community that had a swimming pool right next door, I would love it if they could still occupy it and do so safely. But I also understand living in a community comes with certain restrictions, and it's not my decision of whether or not something that the entire community can use should stay open or not. So know that you as a board, as long as you've gone through and thought this through you're going to be protected from the business judgment rule, which is courts are typically not going to go too far and second guess you from a decision-making standpoint. And the fact that you have these emergency powers, that's really the basis for this, of how you're making these decisions. I want to talk a little bit just about the mechanics. of how you're making these decisions, especially if there's an executive order that comes out or something where, a story hits the news that kind of puts things into a new light. I think it's perfectly appropriate for the president, for example, to make the decision to decide that the amenities should be closed down and provide some communication through management to let the community know about that. I do think that eventually you want to have, in a manner as practical as possible, a board meeting where the board can meet to further discuss what's going on, the decision that was made. Obviously, I think we're all aware right now we're kind of in lockdown mode for the next 30 days in Florida. But I think it's appropriate for the president to make that decision, but the board should really be brought in and to have a meeting to discuss it. And when you have that board meeting, the membership should be able to participate. One of the things that we've talked about a lot, and it's not in the emergency powers, is having virtual board meetings. I think that I find it definitely defensible if you were to post notice for a meeting and say, due to recommendations and the fact that people are being asked to not congregate, have more than 10 people, and not sit at least 6 feet away from each other, that we're going to have a completely virtual board meeting. Here is the call-in number. All of you are able to call in and listen and comment just like you would be able to for a board meeting. It's just that we don't have a physical location for it. So that's not provided in the emergency powers. However, I feel like that would be a defensible action for the association to take, because what I don't think that, I think if you have to balance it between, well, should we just make decision by email and not have our membership in the loop, or should we be scheduling meetings at least virtually when practicable and have our people call into it? I think the arbitrator or the courts would look more favorably on trying to have meetings whenever you can and at least having a telephone conference. And Jim or Alex, you guys have any thoughts on that?
Yeah, and particularly with respect to board meetings. I mean, look, if there are difficult situations that we're dealing with, even if we can have the benefit of emergency powers, which hopefully there'll be, we'll see some statutory changes come out of this to, loosen some handcuffs, so to speak. But what is a little bit problematic is it doesn't really change to some degree the process of how you can schedule these board meetings and how you can allow members to participate. So I agree with that. I think that's a defensible way to proceed. I think, if there's any concern about the risk, you can always ratify actions on the back end. And in the meantime, I think it's a good idea to give your president some authority to take some action, because, there are going to be circumstances where you're not going to be able to meet as easily or as frequently as you could before. So again, one option is to delegate some of that authority to the president, or for the president to take that action and then have that later ratified on the back end. Where we would suggest exercising caution, though, is using the just pure virtual process for membership meetings.
Yeah.
I think there's where we want to be a little more careful.
Yeah. So when we'll touch on meetings in just a second here, for communication with residents, consider, of course, any type of new e-newsletter or email blast with the status of the property and the amenities. I think owners are going to be looking for information from the community. And I think one of the best things you can do as an association, if nothing else, is to say, here's the status, here's what we're doing in response to this. But mostly that would be, hey, we're following the advice of our local and state and federal administration and health officials, and providing links to that information. Send them to the CDC website on the symptoms for coronavirus and helping prevent the spread, and any other information from a credible source. Now, credible, I understand, can be in the eyes of the beholder sometimes, but it's more of a providing information to everybody, rather than it's, again, you're going to hear us say this a couple times, of providing, well, we're committed to providing for your health, safety, and welfare, and here's what we're doing to protect you. I'd be careful about putting any of that type of language, because that's where you may be undertaking a duty that you may not have understood that you were undertaking and may have wanted to undertake. And then going to the third point, I kind of mentioned this already, but need to continue to have board meetings. Notice can be provided by alternative means. That's where, if you look at the emergency powers under the statutes, it says that you don't necessarily have to still provide 48 hours notice. You have to provide it in as much notice as practicable, and then in a manner as best. So you don't have to then only provide posting on the property. You can choose to provide, if you've got people's email addresses. It's not very clear on this, but I had one community, actually, I know the manager's on this call right now, where she said, look, we have everybody's email, and they use like one of the constant contact or MailChimps, where they can tell if there's a read receipt on it. And that's the way that we're communicating, because by the time you send out a letter, if you're already going to have the meeting, for example, that might not be, practical. So between that and then posting on the property, I think that would probably satisfy the requirements of the statute. the thing too with having board meetings, if somebody was to object as to whether or not proper notice was provided, you can always review that objection and then decide to renotice the meeting and ratify the decision that was made. The biggest thing that I would just try to remind everybody is we still need to see it as business as usual as best as possible, but everybody's kind of adapting. Obviously, we're having this webinar for you. Normally, we'd be happy to have this in some place where we can see each other, and but that's really not what we're able to do right now. So for the same thing for your community, nobody's expecting you to go and sit close together and have a board meeting where everybody can cram in with members there, nor should everybody be doing that. But we still need to kind of adapt to it and try to have meetings so that the owners can still participate, if nothing else, then comment on agenda items, just like if we were in normal times where they could attend a meeting where there's a physical location. But as Jim mentioned, what we've been advising communities, I know a lot of you have reached out to us. If you have an annual meeting coming up, you do have the ability to cancel and reschedule those. That's one of the emergency powers in the statute. There's some interpretation here. I've been of the opinion that if you have already sent out the first notice, for example, if you have a 2-notice requirement for your association, especially for a condo association or a cooperative, or if you're an HOA that's adopted kind of the condo form of election, I've advised some of my clients, I know some of you may be on here, that if you've sent out the first notice and that time's gone by for people to submit their name as candidates, I think it's okay to send out notice to everyone that you're postponing the meeting. But otherwise, if you want to say who the candidates are, I know one of my communities has done that, but that you're not reopening that. You're basically putting a freeze on everything that's happened so far. And then you will send out that second notice at a date when we're kind of comfortable with the fact that we think we can have an in-person meeting. But we are still recommending to wait where people can actually show up to a physical location. There's a couple of problems with it if you try to have a virtual meeting. Board meetings, you already have the ability for board members to appear by telephone or by FaceTime or any other virtual conference where you're deemed to be present live. So that's already been an authority where they can vote on that as a board member. They don't have to be there in person. You don't have that ability as a member. You are always able to show up to a meeting, or you can submit your proxy, or you can bring your ballot on the day of the meeting. So by taking that physical location away, you're preventing somebody that maybe forgot until the last minute, or they've been dealing with a health crisis or something, and they want to show up and actually be able to hand in their ballot or their proxy, and they don't have a way to do that. So that's the difficulty with having a virtual membership meeting. I know I'm working with one management company. It's their policy where any mail that comes in is quarantined for, I think, 3 days, and that's certainly understandable too, to protect the safety of the management company representatives of handling that and whether or not the virus can be transmitted. So you're not even guaranteed that if you have a meeting that any ballots that come in close to the meeting time are going to be able to be used. So that's a difficulty. And then membership meetings by their nature are larger than board meetings. You typically aren't going to have your membership meeting maybe at the same place that you have your board meeting because you know a lot more people are going to show up. It's physically difficult to actually find a location right now that you'd be able to book or be able to use to have a meeting, notwithstanding the recommendations against large public gatherings and everything. So that's what we've been advising. I think if you were to make the decision to completely cancel and reschedule it, I also think that that would be certainly supportable under the statute where you start the process over again. But for communities that have already done it, they don't want to have to start it over and they kind of want to freeze the process. That's what we've been advising our clients on it. All right, let's see. Oh, I missed one here. So cleaning and maintenance schedules. Jim, did you want to talk about this? Because I know we've already addressed it a little bit as part of the common area maintenance and everything.
Right. So as a practical matter, you can consider, obviously, if there's a service provider willing, increasing the level of cleaning in certain areas and so forth. Again, be careful in your communications to people. Don't say that you're going to be cleaning things in a certain frequency if you can't control your vendor, or another order might come out that could preclude the vendor from actually performing. So be careful in your communications to people, but at the same time, if you can perhaps clean some areas more frequently, we believe you have the authority to do that, and it's something you should strongly consider doing.
All right, so, and we have some good questions coming in. I'm going to get to those in a little bit as we continue to go through the slides here. Shelter-in-place order. So we had prepared this really prior to the executive order that came out yesterday. So be mindful, of course, of anything from a federal, state, and local mandates. I know that different counties or municipalities have been coming out with different orders. Obviously, the state of Florida finally came out yesterday with something, whereas some of you, I know Palm Coast was a little bit more of an earlier one to adopt this. And we have different communities in the state that have had these. So be mindful of that. I do have a copy of the order. If you don't have a copy of the executive order from Governor DeSantis and you'd like to look at it, please feel free to email me. I'd be happy to provide it. We can make that available to you. It's important to read it. It basically says they're kind of incorporating from a federal standpoint, I believe, and then really what Miami-Dade did in terms of what's an essential activity. And this can go into, we could have a long discussion, honestly, on essential activities and what's covered and what isn't. But I think the main thing for you guys to take away right now as board members and managers is be mindful of whether or not the association has the authority to enforce this from employees of contractors or entities that you've contracted with versus if they're your employees yourself. Because there's a difference there between telling the company that you've contracted with how they should do business versus if you've employed people specifically. And I think there's a difference between that. There are some things that I have looked at of whether or not security guards or gate guards are considered to be essential services. I think there is some support for that. But I think that there are some employment law issues or potential issues that could come up if you employ those guards yourselves. And I think you should talk with your attorney about that because it's a little bit more of a specific situation. Same thing if you contract for that type of service. So let's say you have an outside vendor that's manning your security guards. I had a good question come in that says, what if we have a guard that we think has COVID or coronavirus, COVID-19, and they're still sending them to work? What are we supposed to do about that? And the question there is, I think you should look at your contract with that company, and if there's a provision in there that you can hold them in default, for example. But many of these contracts don't have a provision that you can require a different employee than the one that you have right now. You're kind of leaving it up to them to how they conduct their business. From a practical level though, and especially for our board members here, you have the ability to hire people, or when they're coming up for renewal, obviously you're going to remember this company if they're sending people that are not safe. Management companies, obviously you make recommendations for lots of your communities. Most of those companies, if they're contacted or if you have reason to believe that maybe that employee isn't notifying their employer, maybe they're showing up to work and they're coughing a lot, you can tell that they're not feeling well, and they might have the observable symptoms of this, and you can talk to them about it at a safe distance, by the way, and check with their employer to see if they are notified of that, and maybe the employer doesn't know. So I think there are certain actions, but it's not as easy to say, yes, you can terminate that contract because somebody showed up that was sick. It's not that easy. We have to take a look at the contract for you, talk with your legal counsel about that, and we can help you out with it. Let's see. The other thing and there have been some questions coming up, and I can show that we have addressed these. What do you do if there is a shelter in place order, or if you have any rule, or if you have closed down the amenity? So what if people are, I don't say flaunting it, but they're basically disregarding it, for example? I know, Jim, you had mentioned it before. It's not the association's job to go in and enforce, you're not law enforcement, basically. The best thing that you can do is contact law enforcement if it's something that they have jurisdiction over, to be able to come in and say, hey, we have this order in place. You're in violation. We've been contacted here. You guys need to go home, be safe, and let them handle it. Don't go in. Just like if we're in normal circumstances right now, if somebody was trespassing and let's say they came off the beach and they were going into the pool for a condo association right on the beach, we would never tell you in that circumstance even to have the manager or board member go down and try to physically remove them from the property. You got to contact law enforcement on that. So that's what we would recommend in this circumstance. In terms of what authority, if you do have a rule that's been placed, some communities, if you really want to try and cut down on it, if you find that law enforcement isn't stepping in, you can meet as a board to adopt specific rules while we're in the shutdown period, for example, and that may lead to a fine if we can document that, and you can go through the fining process per state statute. But what we can tell you is don't expect to get in front of a judge right now if you're trying to get an injunction. That would be the normal route. If it was something that was so egregious or we felt like there was an emergency that we needed to get in front of a judge quickly, you are able, per all the statutes that apply to your community, 718, 719, and 720, you can apply for an emergency injunction before going through either mediation or arbitration. But all the courts right now, they're essentially closed except as to essential functions. What is it?
Yeah, essential and critical functions.
Yeah, and that's pretty much limited to criminal hearings right now for the most part. So judges probably would not be taking any hearings on, hey, judge, we've had a problem with a group of 10 residents within our community that constantly are using the pool. We've closed it down. They have a public gathering, a gathering of more than 10 people. It's a health risk. It would be difficult for us to get in front of the judge right now anyways. As tough as that may be to hear, it's just difficult for us to do it. But can you send correspondence to them? Can you contact law enforcement? Can you perhaps put rules in place? I would work with your manager and with your attorney as to the wording of that rules from an enforceability standpoint. And that may be a way that you can do it after the fact in terms of a penalty, but in terms of in the moment, I wouldn't do anything further than contacting law enforcement on that. The other thing too is, with the limitation on short-term rentals, if you are seeing that, there was that order, that was the first executive order that came out, or at least the more recent one from DeSantis before the executive order from yesterday. I believe it's a second-degree misdemeanor to advertise a unit or property for rent in violation of the restriction on short-term rentals right now. And so what you could do, there's another method. You could contact the DBPR, the Department of Business and Professional Regulations, and if you know who the entity is that's advertising that, that can impact their license as well. That may be another route, but again, it doesn't really help you in the moment to physically get people out of those amenities as you close them down. So let's see here. And so our last real substantive slide before I go in, and I know we have a lot of really good questions. This is kind of the long-term effect. It's the assessment and financial difficulties that your communities may have from this. I just saw the number this morning, I think between last week for the unemployment filing and then today, I think you had 3.3 million last week, and I want to say it was 6-point-something million new filings today for unemployment. Somebody had said, and I'm not saying this is correct, I believe that could equate to almost like a 10% unemployment rate right now. And that's just with the numbers that we have right now. What that all means is those people, if they're unemployed, of course, what's going to happen? They're going to stop paying their assessments potentially if they're under economic hardship and they've been laid off and they don't have income coming in. Sometimes association payments are on the back of their mind. They may be paying their mortgage and their utility bills, and the association payments come in later. And so that's going to be the real difficulty that we see from this. Right now, we don't have any moratorium on collection activities. There is something that was proposed that Congress is, it hasn't really been pushed along too much yet. We're keeping an eye on it. That would basically put a halt to collection of consumer debts, which association assessments are considered a consumer debt. And so that would, in theory, unless it's amended or something, would impact your ability to take collection action against owners that don't pay their assessments. You can imagine how that would affect your community if you had all of a sudden a delinquency rate of 25% of your people not paying assessments and you're unable to take any collection action. The difficulty with that for community associations is you're establishing your budget that you just need to make enough an income to match your expenses each year. You're not trying to make money. And so any income that's less than the annual expenses is going to be a shortfall that you're going to have to come up with somewhere. And so we've had a lot of questions, and we may have some in the chat here. I'll take a look at it. But should we be suspending collection of assessments, or should we communicate to our residents about suspending collection policies or suspending late fees and interest? And we have been advising against that. Jim, do you want to kind of go into a little bit from a communication standpoint?
That's right. There's some room for sympathy, and while also walking the line of fiduciary responsibility. And so what we're suggesting at this time is not to send out a blanket communication saying, hey, you don't have to pay your assessments for a couple of months, or hey, we're going to suspend all late fees and interest. Because what could ultimately happen is, if they're not able to pay assessments, then they might not be paying their mortgage as well. And then that prospective waiver that you've granted through that letter could ultimately be taken advantage of by a financial institution or an investor that might buy that property at a foreclosure auction. And that's not what we want to do. That's a little bit too broad of a brush. We want to benefit financial institutions foreclosing on properties later on. So instead of communicating on the front end, just if people have financial difficulties and contact you in response to collection letters on the back end, then obviously consider working with people, and you have what we call soft costs, right? The late fees and interest, that's not money out of your pocket. So work with people on the back end and be consistent with how you work with them. And you know anything we have right now is probably not COVID related, right? If they became delinquent in January, if they became delinquent last year, then an excuse based on COVID probably isn't meritorious. But if they became delinquent, for example, this month or next month, you're going to know whether there's something that was likely COVID related, and there's room for sympathy and empathy there. But what we're saying is try not to send anything now, granting any prospective waivers to give someone, like a financial institution, evidence to use against you later on to reduce their liability. So that's where we're coming from.
So a couple other things from a collection standpoint and some of the financial issues. I know we have some people on here that I've worked with that are lenders, or and contact your lending institution that you may work with for your community to talk about options that you may have from an SBA loan and whether or not you qualify, especially if you're an association that has employees, for example. With everybody is aware of the CARES Act and what came out with the Paycheck Protection Program, and whether or not your association, if you employ people, if you qualify for that or not, or if there are separate loans like disaster loans or anything else that you may qualify for. I would reach out. You have a lot of good people that work with your community. Obviously, you've got your legal team. If you work with us, you have your attorney, you have your management company, you have a CPA that may be able to provide some assistance, depending, maybe a little more down the line. You obviously have your lenders that you work with. You have your insurance agents if there's a liability issue that comes up, down the road. So work with the people, the professionals that have already been helping you with your community. And the first part of that is your financial institution, and talk to them and say, what options do we have as an association? The other thing that you just want to be mindful of, and I've had this question come up, is, well, we have these reserves and we don't really have any projects that we are anticipating doing within the next 6 to 9 months. Are we able to use those reserves for to help any shortfall in the operating because people stop paying dues, and then we can catch up later? And unfortunately, there's nothing in the emergency powers that give you the ability to use reserves for other than their intended purposes. There is a provision in the Condominium and the Homeowners Association Act which says reserves are meant for their intended purpose, but if you want to use them for other than their intended purpose, you have to have a member vote. And the member vote is a majority of the members appearing at a meeting where a quorum is met. So by default, you have that law that's still in place. Nothing in the emergency powers changes that requirement, unfortunately. The only thing, if you look at it, it's kind of at the bottom of those emergency powers. It says that you're able to basically take out a loan and pledge as collateral, even if you might otherwise require membership approval. The board can do it, but that's still taking out a loan. That's not necessarily using reserves without taking out a loan. Could I see you taking out a loan and maybe pledging your reserves as collateral? That may be possible. There's still some issues there because now the reserves could be used for other than their intended purpose. But you do have a little bit more looser restrictions as to borrowing money, but not necessarily for using reserves for other than their intended purpose. So just be careful with that because that could be the basis of a complaint. If you're a condo, the division can investigate that. And they usually take it very seriously. I've been through that before, where they will look at the association's use of reserves and if they're using it for operating expenses or not. So with that being said, that's what we have for our PowerPoint. I'm going to go through, we have a good number of questions here. I'm going to try to go back and answer most of these. And if we can't answer them because they're more specific for your community, please reach out to us. It may just be more of a specific community question. We're happy to look into it further and give you our advice, or of course, talk with your legal counsel about this. But the first question is, can we hold board meetings on Zoom if we post the meeting and allow call-in questions? I think I pretty much answered that previously. This is what we're using right now. Zoom is a good, we found it to be a capable software, although you need to be mindful of privacy concerns. I did see that somebody filed suit and there were some issues with privacy and data being provided. I think something through Facebook. There was something regarding that. So I know that they are making changes to their software to provide a little more safeguards and protection. So just be mindful of that. I think the term is Zoom bombing a meeting, if I have heard that correctly, that people are chiming into that. But yes, I think that while it's not provided as an emergency power under the circumstances, because there really isn't a good physical place for you to meet where it would be safe. I think Mike before joked about, meeting in a parking lot, that I guess in theory could work. But for the most part, I think that the virtual board meetings would be defensible so that you can continue to conduct business. Let's see, a question about providing the materials. We'll be happy to, if you want to reach out to us, I can provide a copy of this PowerPoint. If you send us an email, we'll be happy to provide that to you. Question that came, should I shut down my pool area? I think we addressed that before, that it's difficult for us to give you a black and white answer. Be mindful if anything comes out from a local mandate, for example, and then talk with your attorney. If you do have some questions regarding what your local government municipality may be doing versus what the state order is, or if you've heard from other counties, we just want to be mindful of that. But for right now, I know at least up here in Northeast Florida, there hasn't been anything directing pools to close. I think then it comes down to, can the association react to what it's seen and how people are using it, and can it make the decision to close based upon people not safely congregating? I think that it would certainly be defensible, but I don't know that you have to do it either. I think that's probably the best way to answer that right now. I think we answered this question. We have closed our facilities, but still have residents using parks and playgrounds. Because we do anything about this? Again, as best you can do is notify them that they're closed, and that, and then you can contact law enforcement. They may consider it to be, maybe they'll at least go and talk to the people and get them to go home, but they might not consider it trespassing, because they, under normal circumstances, have the right to use that property if they're otherwise an owner or a guest. So in the moment, I think that's your best option. But aside from that, I wouldn't take any action. You don't know how people are going to react if you go out there and try to physically keep them or bar the way. I wouldn't want to put yourself in that position, especially you as board members. None of you are getting paid to do this. Don't put yourself in harm's way like that. As best you can is just document it, send them notification of it. If it continues to be a problem, perhaps have a board meeting where you adopt it as a rule specifically. Maybe you adopt a rule that says that if the association has otherwise closed down the facilities in response to an emergency event, any violation of this rule may result in a fine of $100 per day or something like that. That may be a way, but it's a after the fact thing rather than an in the moment thing. There was a question about language I mentioned the tennis court. If there's a sign that comes up, we would just recommend that you contact us or contact your attorney for language on that. It's just, we want to look at that specifically, and it just depends on the context of your community. I should say that the emergency powers, they do defer to your documents if your documents otherwise don't otherwise conflict with the emergency powers. You may have other emergency powers in your documents, and that's where it is a little bit more document specific. So we'd want to take a look at that, but generally speaking, you want to say something that you use it at your own risk. We're not providing for your health, safety, and welfare, and you're recommended to check out these materials from the CDC or whatever. That's a general, but I would still recommend that you talk to your attorney about any notices that you provide about closing down amenities or anything like that. Non-residents crashing pools, and the comment was that they're closing the pools due to safety. I think that would be a valid reason, especially of people that are trespassing. Not only if you don't have a problem necessarily with your owners, but other people. That's even more of an incident, though. I would call law enforcement to make sure, because other owners, they may challenge whether or not you should have made that rule, and they may consider it a civil issue. But if they're trespassing, call law enforcement right away. A good question from Jim. If in high-rise, can contractors be prevented from completing work on units? In other words, can you lock the building down to vendors? This is it's a difficult question, because you're still walking that line between, do I have to take all these actions to keep people coming in? And are you now undertaking more of a duty? The more that you lock down, are you undertaking more of a duty, or making it seem like you are, to provide for the health, safety, and welfare of your owners? There could be some monetary ramifications, or something that owners could be, they may say, look, I get it if you don't want me to use the pool, but don't shut down my project that I have going on right now. I mean, Jim, do you want to comment on that?
Yeah, and there could be document issues, governing document provisions, which might affect your ability to be able to prevent contractors from coming in. I mean, a lot of governing documents will have easement language, and a lot of times that easement language will inure to the benefit of contractors and invitees of owners. So, and that could also lead to financial consequences, like you mentioned. The contractor says, well, now I have to remobilize, so now I'm going to charge you, owner, more. And then owner's going to say, well, I wouldn't have had to pay this expense if you hadn't kept them out. And I can say, the government's not saying that these people can't come in and work, so why are you, right? I would be apprehensive before trying to exclude contractors under most circumstances. If you have an extenuating circumstance or a serious problem that they're causing, perhaps, but otherwise, maybe it's a plumber, and the people, to the extent they're confined to their home, they might need their plumbing to work. So circumstances might, justify different processes, but as a general matter, I don't know that we want to get in between contractors and owners.
Yeah. The next question is pool, bathhouse cleaning responsibilities and additional steps to take. I think we addressed this on the cleaning part, which was If you choose to undertake those additional actions, I think that it's certainly defensible as a common expense. If you're already providing for janitorial and cleaning services and you choose to increase the standard or the frequency of that, I think that's appropriate if you choose to do it. I just don't know. I'd be careful about, again, advertising that you're doing that in a way that makes it seem like you are trying to provide and protect the owners. I know this is constant refrain that we've had. It's the method of communication. So it almost would be better if you did it, if the main goal is to protect people, whether or not you're telling them that you're protecting them, then go ahead and increase it. And I think that that's a proper expense. If you're worried about your budget and you say, well, we're going to go over budget for the year, remember, a budget is an estimate of expenses. And I don't think that anybody adopting their 2020 budget anticipated that you might have higher maintenance or janitorial services because you have a pandemic and you want to increase your cleaning services. So don't worry about that if you're worried about what your budget amount is. I would be more careful about how you're communicating that to your owners. I think we addressed this regarding signage on the pool. Can we keep our maintenance man employed? That's a specific question for your community. I think that if you have projects, we'd want to take a look at that for you. It's tough to answer in the moment, depending on if you have a contract in place. Do you not have a contract, in which case Florida's terminable at will from an employment standpoint. So I think that you should address that, any concerns and whether or not there could be potential liability if you let somebody go. Yes, otherwise you can keep them employed. And I think the question is, it goes back to, if you directly employ them, does that conflict maybe with the current order on essential services, and whether or not you're basically requiring somebody to violate that or not. We'd want to take a look at that for you and what services they're providing and whether or not that fits within the order. The question was, is there a way to continue normal business, including voting? We mostly address this from the standpoint of, it's difficult to vote from a membership perspective without having a physical location where people could otherwise show up and cast a ballot. So if it's a membership issue, I just recommend postponing that meeting to a date where we feel comfortable that it'll be safer for people to show up. Or maybe we may get some guidance, and we'll see as to the enforceability of that. Maybe they're finding that associations are being hit hard, and they put something out there from the standpoint of that maybe the division comes out and interprets it as allowing virtual membership meetings. I'm not sure that the division has the ability to enter an order like that, but we could at least look at it. But until then, I think we want to wait to have that and have any type of member voting until we can do it in a safe manner. If I could provide one exception to that, I did have a question that was interesting, which was, we have an election and we were going to send out our second notice, but the only item of business was the election, and we had 3 people running for 3 seats. And the way that I answered that was, you take your seat as a director, even if you don't have to have the election. In the Condo Act, it says upon adjournment of the annual meeting. And so what you maybe could do is send out notice and say, look, all we're going to do is we're going to have a manager and maybe a board member there to help open up the meeting, show that a quorum was not met, that we did not need to have an election because we had 3 people running for 3 spots, and recognize them as taking their seat as of that date, and then moving to adjourn the meeting due to lack of quorum and any other business. And that's kind of, and I saw it to me, I gave that advice if they wanted to try to do that, and just let people know, please don't show up. There's nothing that you could vote on anyways. I suppose if they wanted to, you couldn't prevent them from coming in though. So that's the thing to remember. So I could see maybe that issue if you knew you weren't going to have anything to vote on, to try to hold it in that way so that you're not waiting a couple months before you want to seat your new board members. But again, talk to your attorney, and we want to look at your documents, because that is document specific, and that same rule or provision in the Condo Act about directors taking upon adjournment of the annual meeting if there isn't an election isn't in the HOA Act. So we'd want to take a look at your documents and help you as to what your election process provides. Let's see, we talked about collection of assessments. There was a comment here that the community has a beachfront cabana and the deck. After calling St. Johns County emergency hotline, they closed the deck and the cabana. The advice from St. Johns County was to close because it would encourage groups larger than 10. And so they did, and the residents weren't happy. It's probably a lot of that's going to go on, and that's understandable. Yep. Patty had a good question about proxy eligibility for postponed annual meetings. Should we do another 14-day notice when a date is finally selected, or should we start over from scratch? You know, I guess that is a good question of whether or not, if you've never sent out the second notice, does the proxy run from the date of the originally scheduled annual meeting, or does it go from when you re-notice it and when that second notice goes out from that date?
Yeah, and another issue to piggyback on that, the proxy is supposed to say the date, time, and location of the meeting.
Mm-hmm.
So if you've actually had to change that date, time, and location, then technically there's an argument that the proxy doesn't have valid contents.
So what we need to be mindful of is we need to look at, if you are postponing it and you're not starting from scratch, we need to look at how late that meeting is scheduled and whether or not the proxy could still be valid if it's based upon the date of the original meeting versus the postponed meeting. So it's a good question from Patty, and something that maybe we'll get guidance on from the division, for example, if they issue another order, or we'll have to interpret it and provide our best guidance for you as we get closer. Hopefully we can have meetings maybe in May, late May or June or something like that, that are still within your 90-day window from when the proxies were valid.
Yeah, and absent that, you can always send another proxy with the second meeting notice anyway.
That's true.
And that would probably be your most conservative course of action.
Yeah. Another question is, are all HOA management staff and access control essential employees, and do we have to provide employees with a memo or letter to say that they're essential under the governor's mandate so they do not have a problem coming to work? If so, what should it say? Contact your attorney. We want to look at that. Again, I'm sorry, but it depends on your community and the type of services that they're providing, and we need to synthesize that with what the current orders are. But for the most part, what I'm seeing is that landscape services are considered to be essential under Miami-Dade for both commercial and residential. I've seen security services. I've seen there's a kind of a blanket requirement for professional services that could arguably be, the management company from an on-site perspective. So we're still all, interpreting this as we go along, but I think that there is enough under here that many of the people that you work with from an association standpoint probably fall under the essential services, but I think you should reach out, talk to your manager if it's regarding an employee or a contractor, for example, and then of course talk with us or talk with your attorney if there's a question about this and maybe some of the language and potential liability if you're directly employing people. A similar question, the next one was, if you have gatekeepers, are you required to send them home or will they still be able to work? We should look at it, but I think that that if you're considering under security services, that may be a way where it's specifically identified. But we need to look at this further. It just came out yesterday, but I think that those probably would be included as part of the essential services there. This is a good question. Can we prevent visitors from entering to see family members, especially since we may be looking at a 2 to 3 month shutdown? Again, it's difficult locking out visitors and contractors and people that otherwise may have permission from the owners to visit the property. If you choose to do it, it would be under those emergency powers. Jim, do you want to mention anything or what we think about communicating on that?
Yeah, one thing to be careful of is people are allowed to deliver goods to others. So you might be prohibiting someone who's trying to bring some groceries to grandma, for example. So I think, even if you try to implement such a rule, which is debatable, you would have to have a system for exceptions because, again, people are going to be need to giving groceries to other people and things like that. And some people have disabilities and need to be visited by other people who aren't technically family members. So I don't know. I think you'd have to be very delicate in having that kind of a policy.
So kind of going along with that, this is a good question from Patrick. It's kind of related to some of the other questions about ongoing construction, allowing people in. We had one community that said, we're going to keep our gate open because we don't want people touching the security pad. And whether or not that is something where, should we leave our gate open because we don't want people touching that security pad? Well, there's two things you can handle for that. Owners may be upset that you're leaving the gate open because that's a way to, to have access control for who's coming into the community. If you wanted to protect, to protect the owner's right to whatever you want to call it, I don't want to say security or privacy, whatever it is, but access control, you could keep the gates closed, but put a sign up next to the keypad that says, look, you're using this keypad, I hate to sound like this, but you're using this keypad at your own risk, or if there's a way for you to call, maybe if you have a way for them to call the owner and have them dial them in so they don't have to touch it, you could put something like that up if you're worried about them getting sick. I was talking with Sean, I know he's on this right now, he's an insurance agent, and some of the potential theories of liability on this stuff. And you can only go so far. And when we say all this from undertaking and maybe bringing on additional liability, please understand though, it still would be really tough to prove that the association was somehow negligent and that it caused somebody to contract coronavirus. it would be very difficult to prove that, because you don't know how many places these people went, and they went, and touched certain things, who they've been in contact with. But where we're coming from with this from a liability standpoint is, if somebody got sick and they were in the community for a long period of time, and that community sent out something saying, hey, we're going to make sure that you guys are safe and healthy, any personal injury attorney, and I'm friends with a lot of good personal injury attorneys, and it's no slight against them, is that they are going to see that as, this is an association that has an insurance policy. It's probably going to be under your general liability policy. There may be exclusions. You need to take a look at that, of whether or not there's exclusions for something like this, or under your directors and officers liability policy, if they felt that the board improperly acted, or they did something that was outside of what the board member should have done that would create some type of liability there. Everybody knows that the associations have money because you have the ability to assess your owners, that you probably have insurance. So you don't want to give additional ammo, and that's where we keep talking about how you're communicating to owners on this stuff. It's not so much that we think that it would be a good case that somebody could prove that the association was negligent and caused somebody to contract the virus. It's more that it's more likely for somebody to bring the action if they feel like they've got some tools in their pocket because of some communications that the associations put out. Let's see. Can two members of the board request an emergency board meeting without notifying members, and then later ratify the results for all members via communication of the minutes? If not, how can we get all board members' input with regard to an important matter? I think the best answer for that is just get a telephone conference. We're happy to, we've been setting up board meetings for our clients. I know management companies are doing that as well. There's no shortage of, telephonic capabilities for telephone conferences or other software items that you can use to make sure that you have a meeting that's open to everybody and that's easy for people to participate. I think that's the best thing for you to do. Now, if there's something that's an absolute emergency, or something happened on your property, or there's a new order that comes out that you feel like you need to meet as soon as possible, and you can only reach a couple of board members, okay, I think that would certainly fall within the emergency powers, which says you have to give notice in a manner as practical as possible, but not necessarily the 48 hours notice. So just be mindful of that.
A little bit of a trick in that question. We don't know how many total directors you have on your board. So is it 2 of
Right.
3?
Yeah.
Is it 2 of 5? Do you have a quorum with 2? So yeah, sounds like a tricky question.
Yeah. Miranda had a question. If you had a condo, if it's a condo and they had a meeting scheduled and it had to be canceled, do we have to send the 2 additional notices? I think if that question means that you had the second notice that was provided, and then you had to cancel the meeting, what I would say is you could probably renotice that second meeting, would be the argument that I think that would certainly be one of the options that the association has available. I don't know that you necessarily have to renotice it. Again, that's open to interpretation, but I would feel comfortable with saying renotice it, provide the second notice again saying, hey, everybody knows we had to cancel this. We pretty much froze everything that was in place. Here are all the same candidates, but we're going to have it again at this date. Just be mindful of the proxies, like that Patty brought up as a good question before, and whether or not you might want to get new proxies so that you don't have the 90-day expiration, which otherwise proxies are good for 90 days from the date of the meeting that's listed in the proxy there. Another question is, can we cancel modification or architecture review committee meetings even if our covenants and restrictions require us to respond to the homeowner within 20 days? Can we stop accepting ARC requests? So the first part's a good question. I know that it says that you're able to cancel meetings. I think that would include if you cancel it and then don't give a response, I think I would, if I were recommending or advising the association on that, I think you'd have a very defensible position to say, no, you can't play gotcha with us with our documents that says, well, you didn't respond within 20 days because we canceled meeting because it wasn't safe for us to hold it, that now it's deemed to be automatically approved. I would communicate with them and let them know it's being canceled for the purpose because it's not safe. But Jim, you might, or yeah, Jim or Alex, what do you think?
Well, I had this scenario, and what I advise is if you're canceling a meeting that's already scheduled because it's happening right now, you don't want to meet in public. But there's other ways. You can have a meeting via telephone.
Right.
There's other practical ways that you can have this meeting and still meet your contractual obligation under your declaration. I would try to do that. Certainly, if you're like the 20th day was the day of the meeting and you have to cancel and reschedule, and then now you're outside the 20 days, that's more defensible than just a blanket, we're not accepting any ARVs anymore. Right. Because there are ways to have these meetings in a safe manner.
Yeah, I agree. So yes, I think it could potentially be defensible if you miss a deadline. But if there's any way you can avoid having to be in a position to make that argument, let's try to get in that position by meeting virtually or otherwise.
Yep. Question is, should boards ask their property managers to suspend drive-through inspections of HOA properties during COVID? A good question regarding violations. I think that there's different ways you can look at this. I was involved in a meeting yesterday where I think the position is basically we're suspending anything where you would otherwise require the owner to have to go out and spend money or go to Home Depot or get something that's not an essential activity because they need to comply. There's nothing saying that you can't enforce right now. There's no moratorium on enforcement actions or inspections or anything. But I think from an empathy standpoint and from a understanding that people are losing their jobs or they may have health concerns, and to otherwise, if they fall behind on something because they're not leaving the house or they're not able to maybe maintain things as they normally would, I would put a little bit of a hold on that. Just from at the end of the day, if it results in a violation, if we have to go in front of a judge or an arbitrator, you can be sure that any person, if they're represented by counsel, they're going to go back and say, Judge, this all started because they're requiring my client that might be 75 years old and has asthma or some type of, as the highest of risk for this right now, asking them to go out to buy something because their property fell below their aesthetic standards while we're in a lockdown mode. Like, you don't want to have that type of bad press or be in front of a judge with something like that. So with that being said, I think it's up to your community. I think you should talk about it. Trash cans, is that something though that people should be able to still abide by those rules? I think they should be able to do that. So be empathetic. I bring this up. I know this was, somebody had provided, one of my friends actually had provided this to me. I think it may have been a fabricated letter, which was from an HOA president that said, and it went out to 150 owners apparently, which said, we have been made aware that you are conducting business activities out of your residence. You're in violation of our documents and we're going to foreclose on you. Basically responding to all the people that are working from home right now. Please don't go after people that are working from home right now. If there's a discussion because they're running their business and there's trucks coming in and out and they're parking and they're otherwise disrupting your community, that may be a different circumstance, of course. But if people are working from home and they're not disrupting your community, and there's also been some decisions on this which have said that working from home from a home office generally may not fall within a violation of a prohibition of commercial activity. So I bring that up. I'm pretty sure that was a joke, but I hope not. But just be mindful of that when you're talking about enforcement. There's a question about, we have a problem with our regular cleaning. Our person stopped working, not sure if she's being replaced. Do we have a duty to make sure our cleaning is at least done up to normal standards? I think you have more of a duty there, maybe because you have a contract in place and if you're paying somebody, more from a contractual standpoint than it is that you're doing that because you're worried that by them stop cleaning that you're going to jeopardize the health and the welfare of your residents. I think that's obviously a concern. So you should look at that and obviously contact them and see whether or not they're in breach, or if you can terminate and maybe safely get out of that contract if you have a contract in place, and they'll go hire somebody else that still is bringing people out and are conducting those services. So, but just be careful before you just say, hey, this person didn't show up, we're terminating your agreement, we're signing up with somebody new, when you may have had to provide some type of a cure period or a cure notice, for example, to give them the ability to fix it before you terminate the contract. That's one thing you need to be aware of before you start canceling agreements right now. Let's see. Readdress, can we readdress guests? What is the numerical limit on the number of guests per condo or unit? That's not, I mean, you might have that in your documents as a occupancy limit, but that may be more from a county or municipal standpoint. And if you don't have it in your documents, but you feel like somebody's in violation of that, you can always report them to code enforcement, although I'm not sure how much activity code enforcement, that's complaint driven of whether or not they'd be out looking at this right now. But again, if you can put it in the hands of the people that are able to enforce, whether or not you have the ability because of what is in your documents, put it in the hands of those people, file a complaint, and at least it's on file, and see if they will enforce it at some point. The next thing, regarding the executive order, does it mean all senior citizens cannot go to work? Health conditions aside, what age limit would you suggest this most likely identifies? I can't provide that in terms of, I've seen 65 and older, at least if you all got that on your cell phone this weekend. Did you guys get that, the alert? There was an alert that, it's like an Amber Alert that basically, I think was from the Surgeon General, I think from Florida, basically said, you know, if you're 65 or older, and or if you suffer from some type of a medical condition, you're advised not to go out. So this is a little bit beyond what we can do from an enforcement standpoint. Again, it may just be, even if you just provide your members with a copy of the executive order and recommended that they read it, I think you're doing your job as an association. Beyond that, you know, don't go out there and maybe people need to exhibit common sense. I wouldn't recommend standing in front of people's doors and prevent them from leaving their units either. Yeah. One question was, I have the DeSantis order. Is there anything in writing from St. Johns County? We don't have anything specifically from St. Johns County regarding a shelter-in-place order right now. The most recent thing was the closing of the beach. Let's see, there's, repeat our comment about restricting access to amenity centers to residents only, no guests. We did this for 5 days prior to closing the amenity center completely based on recommendation of our management. Again, it's just difficult if you have people there that are otherwise able to use the amenities in the same manner as owners. You'd have to have a reasonable reason for allowing only owners but not guests that otherwise have the ability to occupy units or the property. So I think you need to treat everybody the same would be my best guidance on that. This also, that was just this from Mark. I'd asked the same question here. A board would like to know if they can approach owners with vehicle tags from the Tri-County area, New York, New Jersey, et cetera, to make sure they're in quarantine. If you know, can you do that? Can you send them something requesting that they do it? I think there's nothing prohibiting you from doing that. I don't know that there's much more that you can do as an association, unfortunately.
Right. So even if they're not, I mean, the question is, what would you do from that standpoint? We want to avoid the opportunity for confrontation. Again, it's not you as the association's role or duty to enforce law or purported executive order. So rather not get in that position in the first place. To the extent there's not much you do with that data, I don't know that I would go hunting for it. Of course, if you do get some information like that or you don't think people are complying, then let law enforcement handle that and you can communicate with them.
So another question from Brad, it says that renters had to leave early. Are we required to refund them on the unused time? That's specific to the contract that you have in place. I can't really provide you with the general answer right there, except you need to take a look at what your contract provides and if there's any relief available to them or to you, but can't really answer it further than that. There's a question from Kelly about concern about reopening the amenities. There's a question about people congregating there. So I think it's just a general comment of when do we make this decision to reopen? I think it's a difficult one where we just need to, I think if the board is relying upon the advice of proper channels of communication information, again, I say that with the disclaimer that that may be in the eye of the beholder as to who's giving that information and recommendation. So work with your manager, work with your attorney about if it's safe to reopen and what type of communication should go out. But for right now, if you've already closed them or if you haven't closed them, I anticipate, you know, I don't see anything happening anytime until May 1st that we might get some more guidance on this from a general standpoint of when it's safe to have more than 10 people together, for example. It's a good question. Assessments are due in April. Can we allocate the incoming money to the operating budget first to the budget amount and then fund the reserves with the later payments for that quarter? The statute does say that if you have your assessment amount, let's say you have $300 a month for assessments, and that's based upon your budget, of which 270 goes to operating and 30 goes to reserves, that $30 a month has to go to the reserves each month. And I believe it's for the HOAs, but I know for condos and for co-ops, you have to make sure that those monies are put in the reserve accounts within 30 days once you receive those. So you can't say that we're going to put all this into operating at the beginning of the year and then use the end of the year for reserve funds. It's a good question. It's a good way maybe for some flexibility. That could be a creative way of at least, if not, you know, if the division or if they never amend the statute to allow you to use the reserves for other than their intended purpose, maybe you could see a change as to the a suspension of the commingling of the operating in the reserve funds, for example. They may allow you to do exactly what you proposed there, but as of right now, you're not able to do that.
Appreciate the creativity.
That was very, I do like that. Yeah.
There might be one room for caveat without getting too far and too long of a discussion. If you are an HOA, depending on how your reserve account was created, you might have a little flexibility. But if you think you might be in that situation, that's probably not general enough for everyone here, but you might have that option if you want to contact your legal counsel.
So we do have some more questions left. I'm going to try to get through them. We might end it in a little bit, and feel free to reach out to us. But I'm going to go through some more of these just so everybody knows where we're at. So to use the reserves, the full membership needs to vote on it and not just a board meeting, and that would be correct. The statute does say that to use the reserves for other than their intended purpose, it requires a member vote at a meeting where a quorum is met. So unfortunately, that is what's required. You're going to have that at some point. We answered this question about contractors working on remodeling. Can they be allowed in the building? I'd be very hesitant to do that. That comes down to contractual issues with that owner, and they may have a direct financial claim against the association that are prohibited. I think what you could do is provide information stating that, hey, anybody in here, please be safe. Please observe all the rules regarding or the recommendations regarding social distancing and so on. And if your community is thinking about doing that, please contact us so we can help you with the drafting of that and at least just be able to advise and see the best way for us to be able to do that for you. But as of right now, if you're asking the way that we're leaning, I'd lean against that because of the contractual basically issues that would be in play between the owner and the person that they're contracting with to do the remodeling.
Leaning against denying entry.
Leaning against denying entry, right, yep. That's why I have you here, Alex. You can clean up, make sure I misstate anything here. I think we talked about this. Telephone conference calls acceptable for a board meeting. I think we discussed that. There's a question here about our email addresses. You can go to our website. It's flcalegal.com. My email is eronsman@flcalegal.com. And then everybody else is your attorney's first initial and then their last name at flcalegal.com. Let's see. We talked about this from Les. Is there some type of electronic participation required? Yes, you'd want to have that so that owners can at least comment on an agenda item. If you've been to our board certification classes, you've heard me say a bunch of times that just because members have the ability to participate doesn't mean that it's a Q&A session that the board has to answer every single question that members have. You're not required to be prepared for anything that members may bring up. You can thank them for bringing it up and maybe suggest that you'll address it on the next conference call or board meeting that you have. But at the bottom line, and I know, Mike, I know you're on here, but you've been in meetings where it basically said, thank you for your comment, thank you for your comment, if you have people that are trying to get antagonistic with you. So just be mindful of that. Jasmine had stated it looks like the St. Johns County Health Department advised on closing the pools. Whether or not that's a mandate, again, we want to take a look at that. There may be some recommendations that may be more from a public perspective than it is from a private perspective. So whether or not, depending on where you guys are calling in from today, it just depends on your local municipality if they have something that's more strict. And that is one thing I did want to say, I don't know if we addressed it earlier, is that the executive order applies, but if your municipality is more strict, that would control over what the governor has provided. But the order does state that the only time that the executive order from the governor is going to control is if somehow there's a prohibited activity from the statewide level that the local level is deemed to be a permissible activity. In that case, the state would control over it. And if you have a question on that, again, contact us. We'd be happy to help you on it. Okay, yep, we did address this one. Extension of time for arbitration decisions. I know we talked about that, and Alex, you had talked about trying to have an alternative way for whether or not it's in person, or at least trying to have those meetings still.
Trying to get consent from the owner for an extension.
Consent from the owner, sure. If the city has closed their pool, we just kind of answered this regarding St. Johns County. Does that help support closing an association pool? I think that certainly helps you in your decision-making authority. I don't think it creates a mandate, but I think it's additional justification of what you're relying upon as part of it, which is contemplated in the emergency powers, which is you're taking advice from an emergency management or a public health official or somebody that you've retained to give you advice on this. So I think that would certainly be the basis for your reason for it. Here's a broad question, which is, does Florida statute overrule your declaration of condo? And my question to Charlie is, do you have an hour for us to continue talking about that? And I'm kidding, but there are going to be circumstances where the statute may control. There are circumstances where the statute defers to your condo declaration or your covenants. It depends on the issue that comes up, and we'd have to take a look at that for you. What happens if someone in your association contracts the virus? This is a very good question. It's actually one that I probably should have addressed sooner. We've had this question before of, if we know who the person is, should we let everybody know who the person is that contracted it? we would strongly advise against naming people unless they somehow say, look, I contracted this and I've been in the community. I want you to let people know in case they've been in contact with me so that they're safe. I would only do that after that owner provides you with specific consent to be able to do that. And frankly, I'd request that they email you that so you have it in writing. Aside from that, if you have firsthand knowledge of somebody contracting it, I think it's appropriate if you choose to say, we've been notified that one of our residents has contracted it. Due to privacy concerns, we cannot name that individual, but we are using this as an opportunity to remind you to please be safe and to practice social distancing and to only leave your unit when necessary. Look, there's going to be, I'm sure there's going to be guidelines coming out saying that everybody should be wearing protective masks, for example. It's not a requirement right now. I could see it coming out, but the best thing you could do is just advise owners that you've become aware of it and they need to be safe and basically leave their unit or their property at their own risk and just to be safe with it. But I would not go and name anybody unless they specifically tell you to, and I would get that in writing from them. Kelly wants to know, where do we get CDC guidelines specific to HOAs? If you Google it, CDC, I think cdc.gov or CDC coronavirus, they have their own page within the Center for Disease Control, I think is what it stands for. They have all of these pamphlets. There's actually some nice ones there. I know we have some people on managers that I've worked with, or I've sent links there with some flyers that you could potentially use that you provide right from their website. Another kind of follow-up question from there, when the property manager recommended pool closure, they said based on CDC guidelines. I'd have to look, I'm not sure of the CDC, that may have been a more general thing. Again, it comes down to decision-making for your board and how your community is set up and how people have been using it so far, and if you decide to make that decision. Again, bottom line on pool closures, I think it's certainly defensible, but I don't think it's mandated right now, depending on which county that you live in. If we answer this one about guests being excluded from using the pool as well. Cindy wanted to know, if we have a board meeting with the members calling in, are we required to meet virtually? Can we still meet with proper social distancing? You're certainly able, if you can do it. There's nothing prohibiting you from meeting. I would just be mindful of any order that comes out. Even with the executive order from Governor DeSantis, it doesn't say that they're going to be putting roadblocks or they're going to be checking people, asking them where they're going, or physically preventing people from getting somewhere. So could somebody go, or could they complain, and maybe you might get a letter from it, but there's nothing right now that specifically says you cannot meet as a board right now. There's nothing stating that.
Yeah, just consider the room where you meet, because again, people technically have the right, your members have the right to show up. So, maybe don't choose a very small room if you think there are going to be a lot of people attending.
I think we addressed this next one, which is, we have dues notices coming in for June for the second half of the year. Should we reduce the amount or eliminate it? I would advise against that. Continue with business as usual, and then respond to owner questions that they may have. And then we can take a look at that if you treat on a case by case, or if you adopt a policy, maybe that it's related to people who have lost income, for example, due to the coronavirus. There may be a question later on. I know I was emailed one question, so if you're on here, I'll try to answer it, which was, should you differentiate between people? What if you have already been delinquent for a year versus people that all of a sudden you see they stop paying April or May, or if you have a twice annual, for example, assessment that's kind of lined up with the pandemic and people losing their job. I don't know that you have to treat everybody the same in that circumstance. From an administrative standpoint, it would be much easier to do it, but could I see a community saying, for anybody that would like a waiver of late fees and interest due to a loss of job, could you require them to provide verification of loss of employment? I think I could see that happening, but I wouldn't do anything yet. I would let this play out more and then wait to see how your owners react and how they're able to pay. And if you're receiving a lot of similar requests, talk with your manager and your attorney about what you're able to do in terms of providing some type of policy, or what's the best way to do it so you're not waiving your ability to collect later on if you have to, collect from the delinquency, or if a lender or a third party takes over the property later on. Oops. Another question, just more from this presentation, will the questions be included in the recording? If you would like to email us, there's a way for me to pull the questions, and I'd be happy to send that to you. It's not in the recording itself unless you hear me actually repeating it, but if you like a list of the written questions, please send me an email. I'll be happy to do so. Can we close the spas even when 2 people would violate the social distancing guidelines and keep the pools open? Again, I think spas are more likely to have people closer together if you decided to do that, but keep the pools open. I think you just want to help how you're making that decision and the decision making behind that. Jim, what do you think about spa versus pool, for example?
Yeah, so I think that decision would be defensible, but although and don't name the person who asked this question because their circumstances they are unique, and I know who this person is. That's predicated on the assumption that you have control of the facilities you're trying to close, right?
Okay.
If you have a unique situation where a third party might own those facilities, you know, whether you have the unilateral ability to close them is certainly something that's questionable. So, you know, Ed's answer is from the standpoint of if they are your association property or your facilities, I think you could potentially close a spa and not a pool.
Yeah. Another question regarding non-essential workers. Should you notify them to limit non-essential workers on the site due to the executive order? Again, you can provide them with information and remind them of it, but I would not try to interpret that and try to tell people what they can and can't do unless you're going to make the decision to keep people from coming in. And we kind of addressed that in terms of prohibiting contractors and people that have a right per a contract with the owner or some permission from the owner. You can tell that we've kind of been advising against any type of denial on that. So aside from that, can you inform owners of the executive order just for their information? I think that's fine. But taking a step further, I'd just be careful unless you as an association have adopted a policy regarding this. And if you're going to do that, I'd recommend you talk with your attorney because it could have some liability concerns going down the road. If somebody says, you caused me to breach my contract, now I'm being sued by this contractor that couldn't come in, and I'm coming after you because you shouldn't have kept them out. That's the argument that somebody could make from it. Condo, from Michelle, condo board wants to prevent owners from moving in and out using the common elevators during this time. So to answer that real quickly, I wouldn't do anything about preventing elevator access. If you want to put up a sign that says, again, you're using this at your own risk, we're not doing any extra special cleaning for this. But elevators are such an issue because you may have elderly or people with disabilities that require that. I wouldn't try to in any way, aside from letting them know that they're using it at their own risk, I wouldn't try to curtail elevator use. I'd be very hesitant to do that because there's some liability issues. Same thing, and kind of going back to the contractor issue, if you're trying to keep vendors from coming in, the example that I've given is what if somebody's has a vendor coming in providing them with medical supplies, you're not letting them come in and they're not able to get medical supplies that results in some health issue or death, for example. I mean, can you imagine the liability the association may have as opposed to, well, we're bringing one other person in here that might spread or may not have this, we're not really sure, and we're not even sure if they're going to come in contact with everybody. You know, if you're weighing the liabilities there, I'd rather have somebody be able to get their supplies than keeping vendors out. So just an example for you to think about too. And I think we answered Michelle's question too about if you're obligated to cancel the meeting or not. I think it's probably likely that you need to cancel or reschedule if there's, but outside meetings, if you can have it in a safe way that you can post a location for it, I think you could potentially do it. Whether or not you may have law enforcement that's tipped off that comes in and says this is too many people and I think you guys are too close together and you may get a word, it's going to be difficult to have, I think, an annual meeting until the executive order is rescinded and not renewed, and then from a federal level too. Let's see. Can we issue 3-day notices on non-payments to a tenant? You're still able under the statute where if owners aren't paying their dues and tenants are paying rent, you can send a letter to them directly and require them to pay. So there's nothing that stopped that. We will advise you, especially if we're your law firm, we'll have to tell you if we have a collection activity and we're prevented from pursuing that. We will let you know. Right now, there's a moratorium on foreclosures, any type of federal, from a federal, like a FHA loans or Fannie Mae or Freddie Mac, right, or VA loans. There's a moratorium on foreclosure sales. But aside from that, there isn't anything preventing us from taking collection activities, at least as of right now. Our condo has our ballots and proxies held by our management company for our annual meeting. How can we hold a meeting to count the ballots? Again, I'd hold on to those and then think about postponing it or rescheduling it to a later date. Okay, somebody asked a question about wearing a Packers shirt and that Packers can't catch anything. Somebody knows I'm a Packers fan, which I've made broadly known to everybody that has worked with me. So we have a condo owner who's refused to pay his last 2 quarterly assessments because of a water intrusion issue. He now says he doesn't have to pay the assessment that was due April 1st because the government has classified assessments as mortgages. That is not the case. If they're delinquent, we need to proceed with collection activity on there, and we will let you know if we're prohibited from recording claims of lien, for example. Nicole has a good question about hearing and appeals meetings. Whether or not you choose to have those virtually too, that's a little bit, I've been advising some communities, if you can, to try to hold off on those for the time being. The reason is because there have been some arbitration decisions that have come out, whether or not arbitrators have the ability to require this, with due process for people that have been fined, where they're able to present evidence and it's almost like a little mini trial. An owner may say, well, if you're holding this completely virtual, I have some stuff that I want you guys to see, but I didn't know that I have to scan an email to you. They may argue that they weren't afforded a fair shake by way of a virtual meeting. Do I think that would hold up? I don't know that it would hold up, because I think you can say, look, we're having this virtually, we're giving you enough time. If you want us to consider anything, here's who to scan and email it to. If you need to have, or drop it off. If you want to have a witness that would come in, they're allowed, there's an arbitration decision that they're allowed to bring witnesses, for example. You can, we can provide them with an invite to that virtual meeting. So I think you could still do it. Just be mindful of that if you get complaints from it. If an owner is complaining during it that they don't feel like they're getting a fair shake and that they'd rather have it in person, consider possibly adjourning it. I'd rather have it done and show a judge or an arbitrator later that we gave the owner the benefit of the doubt and waited for another month to show that we're being reasonable about this than to continue to hold it over an owner's objections. Now, if it's a repeat offender or something like that, that you can tell that they're using it to abuse the process, I think I could see you continuing on with it, but just be considerate of that. All right. And I think Judy asked the question too about stopping owners to have guests in the pool areas. That's a difficult thing if you're allowing owners but not guests. That becomes a difficult issue. I think the best thing you can do is perhaps, if you're going to keep them open, let them know that they need to follow the recommendations for social distancing and gatherings, and maybe say, hey, if people don't do that, we're going to close them down for everybody. That may be a way that you communicate that to the owners. But I do understand differentiating between owners and guests. I just don't know that the statutory powers would necessarily allow you to differentiate, or if you do it, you just may have an argument from an owner down the line. There's a question that probably should be taken offline about using RVs to quarantine. We can answer that for you. That's a very specific question, Miranda, that we'd be happy to answer for you later on. Let's see, can we touch on the essential letter? I think we've talked about that. If you'd like a copy of that from us, just feel free to email us. We can, I think if you're asking about the order and describing what the essential services are.
Or does that mean the letter that you may or may not need?
Okay, yeah, or if you have employees, or if you want to draft that as an association, again, you may want to say something that we consider this to be an essential service, but again, I would talk with your manager and your attorney about how that is drafted, if there's any potential liability there. There could be an issue, like what if somebody says, I don't think I'm an essential service and I don't think I should have to come into work, but I think you should have to pay me. I think that might be an absurd position to take, but if there's a rub between forcing somebody to come in and then giving them this letter saying you have to come in, here's the letter, there could be some employment issues that come up from that, but it would just depend on your circumstances to what that letter should look like. Okay, we answered this question already on rent. Okay, we just have a couple questions left. Thank you, everyone. Let's see. Should an association be notified if a resident has the virus? I think we touched on that before. An owner wants to hire a personal trainer to give classes in our pool. Can we prevent it? I think there's a couple of things that go into that, regarding commercial activities or how the pool is able to be used. If there's if that person's considered to be a guest or not. I'd want to take a look at the documents as to who's allowed to be able to use, but what do you guys think about hiring a personal trainer?
My main concern is from an insurance standpoint. I'm not sure if someone would become injured in that context, that the association would have insurance. Work with a good insurance agent, one of whom we understand is participating in our seminar today. Work with a good insurance agent, because that causes concern to me. If there's commercial activity being conducted on your premises, that could be an exclusion under your applicable policies, particularly general liability. So, even absent these circumstances, we might want to have some rules prohibiting that kind of work for hire kind of situation, whether it's personal trainers in the gym or swim lessons, and sometimes you got to be a little sympathetic too, because you don't want to stop the person who's teaching people, kids how to swim, but if they're doing it for money, either get insurance for that or preclude the activity. You don't want uninsured risk. You want to limit that. So that's my main concern on that.
Yeah. A good question here is, if you have a collection policy, but you're going to deviate from it, should the collection policy be amended? For example, if you're going to wait before you impose late fees or additional notices before you send out a intent to lien letter, I think that's appropriate. I would do it at an open board meeting and reference that you're amending the resolution. If you've worked with us and we've helped draft that for you, we're happy to draft some amendments for you. Just contact us. But I think that would be the right way to do it, to keep it clean, to show what's in place, that you have it either in your minutes at least that a motion was made, or preferably to contact whoever had drafted it beforehand, ask them to prepare the revised resolution that you think will be voted on, or to direct them after the meeting and then have that attached to the minutes as your new resolution. That's a good question. Okay, and our last question is, can we restrict elevator use to only owners and their guests and have vendors delivery personnel to use the stairs? Again, I'd be careful about differentiating here. I can understand the reason for it is that if you're people that are living there or have been there more are guests versus vendors who are coming from the outside maybe and aren't, of course, self-quarantining. I'd be careful with that, because I'm just trying to give an example. What if somebody's delivering furniture and now you make them walk up 4 flights of stairs and they drop the furniture and now that person gets injured and they say, I couldn't use the elevator and the association sued for it. I'm not sure if that would happen or we would be liable for that, but.
And that's assuming that everybody in the building is on lockdown and never goes out. There's no evidence that the vendor has a greater likelihood of bringing in the virus into the elevator than an owner who goes out to perform their job, essential services.
Right. That kind of goes to whether there's a reasonable basis to do that.
Yeah. So again, it's kind of similar to preventing people from coming in, and if they're working on the exterior or if there's anything going on, just be careful about differentiating for what vendors can do, whether coming in the community or what they're able to use. So with that, we've gone through all of our questions. Thank you all for participating here. We had a lot of people here today. If I can let you know that we are teaching a board certification class a week from today. If you have any new board members in your communities, maybe you had your annual meeting before all this happened, or you had it in the fall, for example. We have that on you can register for that. If you did not receive this and somebody forwards you this and you'd like to join our distribution list, just send me an email. I will make sure we get added to it. And then we will be doing some more of these webinars on specific topics. We talk about finding and enforcement collection activities. We talk about construction defect issues, insurance claims. So as we're in this environment, we're here for you. And one of the things that we provide to you as your law firm is we try to provide you with these educational opportunities and make you aware of things when they come up. And so even if we can't see you in person, we're happy to have you participate here with these webinars, and we're committed to staying in touch and providing you with education during this time. So thank you everyone for joining in, and I'm going to sign off, and we will let you know when we have the video available and how you can access that.